All right, here we go. Beyond our Pennsylvania milk marketing law, beyond the OOP.
Okay, so good afternoon, everybody. I'm going to go ahead and we're going to try to cover this, quickly and just sort of skim along the surface to give people an idea of what else does, the Pennsylvania Milk Board, which is now called, which we'll talk about in a second, do besides the overorder premium, which is, of course, the thing that gets all the attention, or at least recently has gotten all the attention. However, we have sort of made some breakthroughs with regard to their other pricing components, which we'll talk about here. Okay, so advancing here is the formal name change as a legislative action, and that's why Chloe didn't cover it because I was going to cover it here. This was just within this last quarter. Governor signed it on November 6th of 2023, and formally the board's name is now no longer the Pennsylvania Milk Marketing Board, but is just simply called the Pennsylvania Milk Board. Just a terminology change. Nothing else changed as far as that goes. I guess there were some who felt that it was confusing in terms of there being other boards that are dealing with marketing on behalf of the industry itself. In other words, this is not a promotion or marketing end. This is regulating the marketing or regulating, the supply chain of milk, so to speak. So in any event, that was official in this last quarter. Okay, now let's talk about the Pennsylvania Milk Board, and I'm probably going to say Milk Marketing Board a few times erroneously here. Let's talk about the Pennsylvania Milk Board and how it operates and what exact laws it is responsible for administering, besides the overorder premium issues. We'll just try to stay away from that as best we can. That's a drill down topic that we've talked about in the past, and we may even talk about more in the future. Okay, obviously the enabling legislation for the Pennsylvania Milk Board is what's called the Milk Marketing Law, and this is an old one. This is we've probably talked about this on here before, but it dates from 1937, and I think there was a law before that called something like, I think, the Milk Control Law, maybe. But in any event, this is clearly a Depression era type of legislation that was geared towards, and if you read the preamble, and geared towards attempting to give government some abilities to perhaps make the markets a little more friendly to producers, and create some degree of regulatory system. And we'd have to really compare it to the old law. But the bottom line is, it was hard economic times, and, being a dairy farmer is always hard, whether you're in, a worldwide depression or not. But the preamble is very worth reading. It's very colorful language. It's kind of thing you do not see in laws any longer. And, perhaps, consistent with that, and maybe, unfortunately, a lot of the other areas of the law are a little bit old style language, let's just say, which can cause some issues. And I know we have people from the Milk Marketing Board who are the ones responsible for dealing with and enforcing and interpreting that sort of old style legislative language that the law is, still consists of. But in any event, here's I've included the citation for you in case you need it. I love to put my PowerPoints or chock my PowerPoints full of links so you can use them as the resource. And just know that, for our lawyers here, Title 31 of the Pennsylvania statutes, 31 PS is titled food, and that is sort of the old outgoing codification, so to speak. However, there is no 31 of the Pennsylvania Consolidated Statutes. Everything now is going into Title 3 of the Pennsylvania Consolidated Statutes. For example, that's where the new food safety laws went, and that is, 31 PS will be a dead item one of these days. But right now, it still carries a number of statutes that are vital and in effect, and the milk marketing law is one of them. The implementing regulations I've set forth here And so those are the Pennsylvania Milk Board's implementing regulations, and they do get revised from time to time. And there have been some revisions in recent years. And just note that this is not the milk marketing law is not to be confused in any way, shape, or form with what the Pennsylvania Department of Agriculture does on its own under the milk sanitation law. Milk sanitation law is another one of these Depression era statutes that's very old. I think it might be 1935, I think that's right. And but it is the basic statute that still exists today and is still, found at 31 Pennsylvania statutes. And it is it's not actually called the milk sanitation law. It's actually called Permits for the Sale of Milk or Manufactured Dairy Products. But it is the law that regulates the production of milk and the storage and processing and et cetera, the processing end of things, and contains all of the sort of food safety components. And so that is not to be confused with the milk marketing law, which of course is just limited to these activities of the Pennsylvania Milk Board in regulating more or less things relating to pricing in the supply chain, not so much the food safety concerns or the other types of milk handling regulations. Okay, and so when you're looking, sometimes it can get confusing if you're looking for milk and you sort of cross over these two things and you try to figure out, if you're not experienced in what you're looking at, it can get confusing. Okay, the milk marketing law, here's all the sections, and these are links to them all. Obviously, the one that I have the green star next to is the biggie. That's the prices. That's their pricing system. But there are many other things that the Pennsylvania Milk Board does under the milk marketing law. And you can just see some of them here. Bonds of milk dealers, licenses for milk dealers, regulates. There's an article in here all about milk haulers who are also licensed by the Pennsylvania Milk Board. And the weighing and testing of milk, particularly the weighing, since farmers are getting paid by the hundredweight, by the pound. So therefore the weighing of the milk needs to be accurate in order to protect them against potentially getting shorted, so to speak. So that's one of the duties, is to be involved with regulating the accuracy of how dairy farmers are getting paid, essentially. So there's a number of provisions in there, and I'm just going to skim along the surface with some of them to give you a general idea. Here are by the way, again, I did the mistake right here instead of saying the PMB, I put the MMB. It is the PMB regulations now. And this is the chapters of their regulations. And again, some of this, these are obviously large and detailed chapters that arise out of the law that we just looked at. But here's all the links in case you ever need to start looking through them or need something. Now, one of the things that goes on in the milk marketing law is who needs a dealer license. And this is not the hottest issue in the world, but it's still an issue. And so I just figured, okay, well, let's take a look at some of the it's a complex law to sort through if you're not familiar with the dairy industry. So a milk dealer, it's a pretty all-inclusive terminology, and it's important to point it out so that people don't get confused, because there's milk dealer, and then there's this word handler, and then in the modern world we say a lot of times the processor, and all of these things are to some degree interchangeable, but milk dealer and handler are the two sort of preferred terminologies that exist in this older, old style statute. And nothing wrong with them. They work perfectly fine in today's world. So a milk dealer is anybody who purchases or receives or handles on consignment or otherwise milk within this Commonwealth for processing or manufacture and further sale, within or without the Commonwealth. In other words, the further sale could be outside the Commonwealth, but it is, handling milk within this Commonwealth, whether on behalf of themselves or others or both. So you can see that is a big one. And in fact, cooperatives can be handlers and dealers. You can see from that definition. Now, a producer who delivers milk to a milk dealer or handler only shall not be deemed a milk dealer or handler. In other words, the producer who is, maybe there was a time when producers themselves, hauled their milk to the plant, for example. Well, that doesn't make them, a dealer or a handler. Just because, yes, they are handling milk and they are handling it on behalf of themselves, but they're specifically excluded in here if all they're doing is delivering it to whoever is going to take it to the next step in the supply chain. And then here's the paragraph, and this is all verbatim right out of the definition. A cooperative is can clearly be a dealer, as the next paragraph talks about. So that's all I really wanted that next paragraph in there. And it basically says, that cooperatives, if they meet the definition, are governed by all the applicable provisions of the Act as to prices, etc. When it sells, markets, or bargains to sell or makes available on consignment or otherwise milk within this Commonwealth to dealers. In other words, so that just clarifies, the activities for which a cooperative can be considered, a milk dealer or handler. Okay, now, who needs a dealer license? Okay, this is the basic provision that you see that what we were looking at before was the definition. This is now the actual provision as to who needs a dealer license. And I'll just leave it to say that try to read this thing through once and keep your brain straight, and you're a better man than me. You're a better woman than me, because this is an example of how old style this statute is. And my hat's always off to the PMB. I said it right that time, because this is not easy, dealing with a law that is, just old style. That's all you can say. And it's very difficult to administer these laws and keep them straight. You got to do a lot of diagramming sentences to keep them straight, I have to say. Okay, now, there is an exemption for a dealer license. And if you want your brain to be numb after that last one, try to read this one. The bottom line is there is, in fact, an exemption for small guys, small people that are handling very small amounts. Now, I will leave it at that. I will say to you that if you ever need to find out how the exemption is put into place in the real world, contact the Milk Marketing Board for that, because I don't know that this is going to help you all that much when you sit and read it. But it does, one thing to keep in mind is that if you have, and this came up in the raw milk world for those who were, potentially selling, or had a license to sell raw milk, or maybe they didn't, but either way, they may need a dealer license, particularly if they are handling somebody else's milk besides their own, then they are clearly getting into needing a dealer license. Again, contact the Milk Marketing Board on, whether and how the small exemption, the small volume exemption is interpreted and applied. Okay, now, the Pennsylvania Milk Board operates essentially by what's called official general orders. And in that sense, it's like a regulatory agency, like a PUC or something that, doesn't have time really, and isn't in the business of, a statute, a regulation, and that's the end of the discussion. They need to be more flexible, mobile, and and able to respond in short increments of time to changes in market conditions, much like somebody like, let's say, a PUC again. So this is the markets move fast, and this is an agency whose job it is to bring order within the things prescribed under the statute to that evolving and changing market. It needs things like process or instituting rules and implementing their law and fleshing out their law by orders that are entered after administrative hearings that are held in accordance with administrative, law. And so that's essentially the main vehicle for how they operate, not the regulations. The regulations are there to help flesh out the processes, let's just say, but the meat is in these OGO, these official general orders, and they can be a Commonwealth-wide order, or they can be in only a particular marketing area. And you see in this map, the colored areas show you the different, the 5 different, or 6, excuse me, different marketing areas in the state. Area 1 is this Philadelphia, the sort of, pinkish purple down there. And you see the rest of the state all divided up into those marketing areas. Okay, that's important because we'll come back to that later. Okay, so here are the current Commonwealth-wide official general orders, and I just pulled this right off their website, which is quite nicely stocked, full of all the information you're ever going to need, and it's fairly easy to find. Again, for general practitioners and people that aren't immersed in this, and it's hard to, it's hard to dabble in it. You're either in it full or you're not, but you might have clients, if you're a practicing attorney, who, you might have to understand some of these things to understand what's going on. These are the current official general orders that exist on a Commonwealth-wide basis. Everything above where this little red section of 3 at the bottom are, the non-overorder premium orders. The overorder premium, as it is administered today, is essentially embodied in these 3 official general orders that are down in the lower right-hand corner. So there's some of these, as you see, there's some recent ones here. There was a minimum retail pricing order, and not long ago, and then there was a very revolutionary sort of move back in 2020 and 2021 to institute this cooperative milk procurement cost order, which we have talked about that on this, in this webinar series, and I'm not going to get into the details now, but that's a very interesting little thing that happened here in Pennsylvania, where since the advent and proliferation of cooperatives providing more and more of what the processor, the dealer, used to provide in the various services that are needed on the supply chain before the milk leaves the possession of a cooperative to, and is now the property of the plant. The cooperatives are now paid for some of those things, which are historically and are borne by the processor when they don't buy from cooperative members. In other words, the cooperative's taken some of the burden off of them by doing certain things for their members, and now they're being paid for it in Pennsylvania as part of the producer price, which is, that was quite a big thing when it happened. Now, these are 2 other laws besides the milk marketing law that are administered by I did it again, it says MMB, it should say PMB, and my slides titles need to be updated here. Milk Marketing Fee Act was simply an act in 1978 that, I believe what was going on at that time was that the fees were contained in the statute itself and had to be updated in a more timely and flexible manner. So that was all removed from the statute, and the board was authorized to set their fees by regulation. Very common in government to do something like that. And this just happened to be an instance where they broke it off into its own little freestanding law so as not to probably open the milk marketing law itself. And so it just basically deals with how their fees are set. The other act is this Milk Producer Security Act. And there's the Fee Act sections, by the way. I'm going to get to the Security Act in a second. Here's the sections of the Milk Producer Security Act. What's this about? This is about prompt payment, as you see the sections here, and it's about security bonds. And I'm sure many, there are, I shouldn't say many, there are other things in here, but that's the two headline items that we want to talk about that the Milk Marketing Board does besides the overorder premium. So security bonds, essentially, here's just the section itself. Each milk dealer, as required by this act, shall file with the board a corporate surety bond or collateral bond, and it shall be in a form prescribed by the board, et cetera, et cetera. And then down below is subsection C that talks about what the amount, and it says, except as set forth in 2, the milk dealer shall file a bond equal to a minimum of 25% of the highest aggregate amount owed by the milk dealer to all producers for milk for a 40-day period during the preceding 12 months. So they take the highest, accounts payable to producers that exists, and then they have to have a bond for 75% of that. I should say exists in the last year, and then you post a bond for 75% of that. In other words, it's available should a dealer who is, has a large accounts payable to producers goes insolvent in some way, shape, or form. There is, a bond to pay the producers for the milk that has been delivered. And then there's another option, which is there is a fund that you can pay into, and these people are called vested milk dealers under the terminology here, where you can have the amount of your bond reduced to 30% of that, highest aggregate amount in the last year. If you pay into this fund and you eventually build up a balance in that fund that will stay there essentially as the equivalent of essentially a cash bond, so to speak. And then so that is an alternative if, getting a bond instrument for 75% of this, total is too burdensome. So there are some options here. And then when you pay into the fund, you can get to a point where you may not need to pay into it any longer. And you just get your 30% bond. Now, recent insolvencies and bond matters. This is just here because this illustrates to you how important this is. We've had 4 that I can remember, or I should say 3 that I can remember in just the last few years where, thank goodness, these bonds were in place under the Bond Act. There was Trickling Springs, which was a small outfit over in Chambersburg area, and they became insolvent, excuse me, and there was bond proceeds of about $450,000 that were held, and in the possession of the Pennsylvania Milk Board, and they were distributed by the Milk Board to 3 different producers who had a large, bill owed by Trickling Springs, and so everything was taken care of by the bond. So that was a classic example of the bonds being used and being successful. Now, Dean Foods bankruptcy. We've also had the Borden bankruptcy, which you see listed here. The Borden bankruptcy wasn't nearly as, Pennsylvania did not have producers who were selling to Borden who were in any way, shape, or form, impacted by the Chapter 11 bankruptcy of Borden. I believe the Borden was sold, and then I think it was removed from Chapter 11, I believe. If I said Chapter 7, sorry, I meant 11. So the bottom line is we didn't suffer in the Borden bankruptcy. That was a later one. The earlier one was the big one where we did have some involvement, which is bankruptcy, which was at the time the largest dairy processor in the nation. And or at least in terms of the collective assets that it owned and the number of processing plants that it owned. And it was not a cooperative, so it was clearly the largest independent processor. So the that Chapter 11, Dean filed Chapter 11, and they were paying everybody currently. There was a little problem towards the very end of the sale of the entire assets of Dean to DFA, where Dean had left a few outstanding bills to Pennsylvania producers, and then they covered them. So bonds were never never had to be called upon in the Dean Foods situation. However, then we had a really oddball thing happen, which is, and the Milk Marketing Board went above and beyond the call of duty on this one, which was that the attorneys for the trustee, or the trustee, I should say, the trustee in bankruptcy who's supposed to marshal the assets of the debtor, meaning, Dean Foods, they authorized some nationwide collection agency to go after all these milk producers who had sold milk to Dean within the 90-day preference period before the filing of the bankruptcy. And I won't, if you don't, that's bankruptcy terminology, obviously, and debts incurred by the debtor within 90 days can potentially be avoided, and the proceeds of have to be regurgitated back if I shouldn't say debts, I should say payments made, and so in other words, assets transferred out. So the bottom line was, a bunch of dairy farmers in Pennsylvania got these dunning letters from this national law firm up in Minnesota somewhere, telling them that they owed them all kinds of money. Everybody was up in arms. Milk Marketing Board, even though it wasn't really a bond matter, and the bonds didn't have to be called upon by Dean Foods, it was a mess. And they stepped in conjunction with the Attorney General's office, who was, very, very cooperative, and were able to essentially or I shouldn't say skirt, were able to solve the problem by providing proper paperwork for these producers to all file to say that these were not preference payments. These were supplying goods in the normal course of business. This was not any type of attempt to by these people to get better treatment than others would in the bankruptcy. And the bottom line is the situation was taken care of. So anyway, just things that sort of surround the insolvency problem, which the Bond Act is meant to take care of. Now, this is the other three big items that the PMMB does besides the overorder premium. They set
all right, Brooke, you've got about 5 minutes left. Just let you know.
They set minimum producer pricing, they set minimum wholesale pricing, and they set minimum retail pricing. Now, these are not the overorder premium, although the overorder premium is included in the minimum producer price. Okay, this is a table that shows you the minimum producer price. And the minimum producer price, in fact, you'll see there is a little column for the overorder premium right here, plus what's called the fuel adjuster. So Chloe had read about there being the continuation of the $1 overorder premium, and 38 cents is the fuel adjuster. So that's what this column is here, the third column over. Now, this shows you that in each area, there is a guaranteed minimum price. And the guaranteed and this is for, I should say, this is for class 1 milk that is utilized as class 1, in other words, fluid milk. And so I guess I should be very clear. The minimum producer price is for class 1 milk, as it is for the minimum wholesale and the minimum retail. Now, so we get, in all 6 regions, I showed you that map before, we have a minimum producer price. That is not what the federal system technically guarantees, or I should say results in, let's just say, in Pennsylvania. As you see, this is Pennsylvania here, as you see, and this is Federal Order 33 and Federal Order 1, and there's this big part of Pennsylvania, the white part, that isn't covered. And in these federal orders, yes, there is a minimum producer price that ultimately is arrived upon. However, in the areas that are covered by white in Pennsylvania, we don't have a federal order covering those areas. Well, essentially, the Pennsylvania Milk Board covers that by calculating a minimum price required in that white void where the federal orders do not cover. And it's all done by, these regional, the marketing area orders. So there is, in fact, a minimum price right here, this first column, for class 1 milk, or milk utilized as class 1 across the entirety of Pennsylvania. So that's one of the things that it does that is not the overorder premium. Now, the overorder premium can be added to that, but that is a thing that minimum producer price in all of Pennsylvania is something that the Pennsylvania Milk Board, got to keep practicing, gives producers that is different than the overorder premium. this shows you a little bit of the distribution of the processing plants. And if you go back to look at where this white void is, there is some issues there with regard to the fact that the federal order price is dictated by where the plant delivery occurs. There aren't many plants in that white void area, but there are some. So that is, again, measures the benefit that the milk marketing law and the Pennsylvania Milk Board provides that is not the overorder premium. Now, but the bigger benefits are the minimum wholesale and the minimum retail. The minimum wholesale is the price that dealers get from those who buy it from them, meaning grocery wholesalers and grocery chains, and anybody else who's going to resell the milk in a retail setting. And Pennsylvania sets a minimum price at that juncture in the supply chain so as to, and the justification is generally voiced as, it is so as to prevent bidding wars and retailers coming to processors and essentially trying to get these rock bottom prices from them that are way below their costs, so that they end up selling milk at a loss, which then, as a matter of policy, ends up hurting everybody, back through the chain, all the way back to the farm. So the idea is to cut down on, price wars, generated by retailers wanting better and better and better prices, and processors having to slash and slash and slash to the point where they're selling under cost, and then they end up having to go back to the producers in Pennsylvania and try to get them down and pay them less. So that kind of cyclical race to the bottom is meant to be addressed by this minimum wholesale price that dealers enjoy because of the pricing system from the Pennsylvania Milk Board. And lastly, same thing at the retail level. Again, the retailers enjoy a minimum retail price so that they are not competing with each other with sales of milk. And if you'd never understood it, there's no such thing as a sale of milk in Pennsylvania, because there's tiny little circumstances, but the bottom line is there is this is why you don't see specials $1 a gallon or something of that nature, because we have a minimum price that retailers are entitled to get by law, which keeps them from, engaging in price wars over milk, which just produces backwards pressure on the processor, which then just produces backward pressure on the dairy farmer. So the idea is to cut the race to the bottom and eliminate it so that the dairy industry is not hurt by this competitive race to the bottom, so to speak. So in a nutshell, that is essentially the Pennsylvania Milk Board, other than the overorder premium. Now, our drill down topic in the future may be to synthesize all that together and show you how the overorder premium is part of that minimum pricing system, but it isn't the minimum pricing system. The minimum pricing system is a different animal altogether. And just to show you that the Milk Board is thinking ahead, they have already, because they know that there are people disgruntled over the minimum wholesale and minimum retail, they have already retained an economist to do a economic impact study of eliminating the Pennsylvania minimum pricing system, and it's all available on their website. There's the report, and there's a graphic from the report, which I'd love to go into, but we don't have time. So with that, I will turn it back to you, Audrey.
Awesome. We've got a couple of questions, and we're just a little bit over time, so we understand if you need to, log off at this point, that's fine. But we'll do some questions here and go into overtime. And we've got I'm going to go back to Mr. Agner's question. And so I think he was talking about overorder premium as a price support. Why doesn't every dairy producer benefit from the price support?
That is overorder premium. Okay. Well, first of all, maybe this is hard to get all of this into one little answer. Basically, number one, the overorder premium, so if that's what we're calling the price support, the overorder premium, it's not really a price support, but the overorder premium is only for fluid milk, number one. A very small percentage of the, total subset or the total set of dairy producers enjoys that their milk is utilized for fluid milk. The majority of dairy producers their milk is going for cheese and butter and other things. And many times the decision, of course, as to what utilization is made from that milk, what it's used for, is not up to them. It's up to somebody else over whom they have no control. So that's an attempt to try to answer that. I want to try to get this slide off of here. I got to end my sharing. Go ahead. Next one.
We've got another great question by Ms. Bickford here. If Pennsylvania Milk Board is responsible for setting prices for Class 1 milk, why do they set sour cream prices? Isn't that Class 2?
Yeah, and I don't know where she's getting I should go back to my slides because I would have that chart. I don't know that there is a minimum price for sour cream, or it may be within the definition of, I don't think so, a fluid milk. I know we have people on the line who could probably answer that question.
I see somebody with their hand raised. I'm gonna allow this person, Mr. Stoken, I believe. Mr. Stoken?
Yeah.
Maybe that was a.
Yeah, I'm not sure if this person wants to send me an email, tell me what they're talking about in terms of the sour cream. Oh, I see. It is actually in the, let's see. It's in the chart that had the minimum retail. Let me see here. Yes. Okay. So I believe it is classified within the same classification as fluid milk, and that's why there is a minimum price.
Okay.
I think that's correct.
Okay, and then let's do with the other president. Does the Pennsylvania Milk Market or Milk Board operate a state pool to redistribute the overorder premium?
No, and that's the whole crux, and that's essentially the federal system, so to speak. And that has never been anything that Pennsylvania has taken on. Probably for a good reason. It's not to say that when this law was written, there's actually some language in there that talks about things of that nature potentially being possible, but there are other holes in the law where that kind of thing couldn't happen with the current status of legal authority for the milk board. So, that's a major undertaking that has all sorts of problems and conflicts with the federal system. But that's replicating the federal system at the state level. And I guess there's questions about how necessary is that if you already have that in the federal system.
Right. All right. Well, I think that was all our questions. I still am not sure. We had a question from an anonymous attendee about a surcharge, and I don't know if that was referring to Canada.
Yeah, right. That was those questions there when at the first portion. I don't know what they were referring to. So,
right.
Okay.
So we will go ahead and wrap this up. Thank you all so much for joining us this afternoon. And that concludes our program for the Dairy Quarterly Legal Webinar. Join us again for the same type of webinar in April. It'll be April 16th for the overview of U.S. state milk pricing systems. And hopefully we'll see you there. Thanks, everyone. Have a great day.